Thank you. So critics call it Florida's free kill law. It limits who can sue over a death from medical malpractice. Earlier this month, 10 Investigates Jenna Bourne fact-checked the arguments that have kept this law on the books for more than 30 years now. Tonight, she's breaking down the bills filed by state lawmakers to change that.
Florida lawmakers have filed these 5 bills so far for the upcoming state legislative session to modify or repeal it. I'm going to walk you through each bill, but first, let's talk about the law they're trying to change.
I not only lost a child that day, I lost one of my best friends.
Cindy Jenkins' daughter, Taylor, was rushed to the hospital after a car crash. She says doctors didn't notice a torn artery until it was too late. She wanted to sue over her daughter's death, but no medical malpractice attorneys would take her case.
She had just turned 25.
If you are 25 or older, unmarried or widowed, and have no children under the age of 25, you're what critics of Florida's law call a free kill. If that's you, subsection 8 of Florida's Wrongful Death Act says your loved ones can't sue the doctor or healthcare facility for mental pain and suffering damages.
It's a balancing act, and anytime you're looking at any segment of the law, there has to be a line drawn somewhere, and the legislature chose to draw it where it is.
Supporters of the law say it helps keep medical malpractice insurance rates down in Florida, which helps keep doctors from leaving the state.
I think it's dangerous to start removing those protections and then finding out whether or not, in fact, we needed them.
State Representative Spencer Roach has filed one of 5 bills for the upcoming legislative session to change this law.
The living can sue, but the dead cannot. And we call that a free kill because it's virtually free to let the patient expire, but it can potentially be very costly if you save their life. So it's this perverse medical incentive to let someone die rather than try to save their life because you're trying to avoid a medical malpractice suit.
Roach's bill, House Bill 77 and Senate Bill 310, would partially repeal subsection 8, eliminating the part that says parents of an adult child can't recover damages for malpractice. So moms like Cindy Jenkins would be able to sue. But people like Tamika Gansey, whose unmarried mother died, would not.
Making sure that someone else doesn't go through it with their mother, that is what I want.
House Bill 129 and Senate Bill 442 would fully repeal subsection 8, so anyone could sue for damages.
We know that the majority of our doctors are very responsible. This is not against the medical field. We know that accidents might happen, but we also want to make accountable the ones that are not doing, the right thing.
State Senator Clay Yarborough's bill, Senate Bill 248, would allow the people currently blocked from recovering damages to do so, but only if the Agency for Healthcare Administration or Florida Department of Health find there was probable cause of negligence first.
Do we want our good healthcare practitioners to leave the state? No. But at the end of the day, do we want to make sure we value all life the same way? Yes.
Jenkins says that bill doesn't go far enough.
What this bill really does is plunk Mount Everest in front of family members that have just lost their loved ones. And if you can climb Mount Everest and make it to the other side, and ACA or DOH finds probable cause, then you can have the same right as everyone else to our judicial system.
At least 6 similar bills have died in committee over the past 2 years. Florida's legislative session starts January 9th. Reporting, Jenna Bourne, 10 Investigates.
Well, take out your phone if you want to check out Jenna's original investigation into this law. Scan this QR code with your camera app. It'll take you to Jenna's YouTube series, What's Brewing, and this investigation is the video right at the top of the playlist.